Hey, 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 all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within for the Commonwealth. Your Honor, give your attendance and you shall be heard. I'll say the Commonwealth of Massachusetts, court is open, please be seated.
Good morning, welcome to the Appeals Court. I'm Justice William Meade. With me today are Justices Massing and Brennan. Will be your panel for all of the cases we hear today. As you know, each side gets 15 minutes. We have read everything. You needn't use all of your time. We do not entertain rebuttal. And with that, I'll call the first case, 25P366, Commonwealth versus Feliciano. Mr. DeMello.
Thank you, Your Honor. Kevin DeMello on behalf of the appellant defendant, Mr. Alexis Feliciano. This case is about the appearance that the defendant's sentence was based on improper considerations. We don't dispute that crimes were committed or that he violated his probation. Instead, we argue that Mr. Feliciano was not treated fairly at his sentencing for the violation of probation. We argue that the sentence was tainted with the appearance of partiality because it appeared to violate double jeopardy principles, and it appeared to be based on the improper personal views of the sentencing judge. The appearance of a violation of double jeopardy is based on a sentence that appears to add additional time to a part of the underlying sentence for attempted murder, which the defendant had an expectation of finality because he had fully served that sentence. To the extent the violation of probation sentence was based or appeared to be based on that attempted murder charge, it should be a violation of double jeopardy.
I ask you this, the sentence, that the probation sentence, that was for the assault and battery with a dangerous weapon.
It was...
That he was being sentenced on after the violation.
Correct.
And the conduct underlying that is the same conduct that supplied the factual basis for the attempted murder. The strangling her with the phone cord.
Correct. It's the same conduct.
So why couldn't the judge consider that conduct that he found shocking to be the basis of his sentence, since the assault and battery dangerous weapon was part and parcel of the attempted murder?
So I think that's a very good question. I think that's the crux of this.
Thank you. I worked hard on that one.
And what I would argue is that this is a case about appearances. And to the extent that his comments on the record created the appearance that he was sentencing Mr. Feliciano for the attempted murder charge.
Well, how do you get that appearance? The probation says, we recommend on count 5 a 5-year sentence. The ADA says, Judge, you got to consider the guidelines for assault and battery. The judge says, on count 5, I'm giving the guideline. Where's the appearance that he's doing it on count 1?
So the appearance starts with, first of all, he says the guideline says 60 months at the low end. And if you look at this case, it's the only way to get there is for this to be a level 7.
6.
Well, it would be level 6 with a serious or repetitive record, but to get there, you need to count all of these prior charges that are well past the decay period.
So let's say the judge just wasn't very good at the guidelines, which are not mandatory, they're what they are, guidelines, right? Would that invalidate the sentence if the judge just kind of got it wrong? I guess I thought I could consider all these old ones as part of the guidelines. Regardless of that, I consider them.
Right, and I think it's totally possible that that's what happened. I don't know what was in the judge's head. We can't speculate on that. But what we know is what the appearances were. And when he says 60 months at the lower end...
So appearance to whom? Appearance to somebody who knows the guidelines inside out and really is familiar with them? Is that kind of where we're heading with that?
So I would just fall back on the case law and say, the case law is clear that the judge must avoid the appearance of any type of partiality. The appearance that justice was not done here.
That's, I guess, what I'm asking. Why is that partiality as opposed to what if it was just a slight misconstruction of the sentencing guidelines, if that's what it was?
I guess what I would say is an uninterested observer looking at this case would hear that sentencing argument or hear that sentencing rationale and say, it sounds an awful lot like this guy's being sentenced on the attempted murder charge and not on an assault and battery with a dangerous weapon charge.
You don't dispute that if this was after trial, the judge could have given consecutive sentences?
I don't dispute that.
Okay. And with respect to the appearance, it strikes me that what the judge did here is just what we want judges to do at times, which is when the judge looked at it and said, wow, these facts are so bad, I need to take a step back and take a breath and give it a few days before I come in here and sentence, because I don't want to be in some way, in terms, we're talking about appearances, I don't want to be in some way informed by an emotional response to this horrible crime. Isn't that what we want the judge to do in that situation?
I think that was a wise decision by the judge, but the problem is he came back 2 weeks later and starts talking about how this was shocking and how he's concerned, he's worried that sometimes we see so much violence, and so that suggests to me that maybe the 2 weeks wasn't enough. Maybe he should have thought a little bit more and say, maybe I'm not the right person to sentence this guy.
Okay. Or was it just a contextualization, saying, where does this fall, where does this crime fall in the spectrum of all the crimes that I've seen in my long career? And look, I've seen a lot of things, and in some ways you get inured to the violence, but stepping back from it, this is violent and this is why. It just strikes me that that's just the way you want to go about it if you want to separate the emotion from the analysis.
Right, so again, I don't want to speculate about what was in the judge's head. All I want to do is focus on what this appeared to be. And I think another important key fact is the probation officer here, when he's asking for this particular sentence, he says, frankly, the defendant attempted to frankly kill the victim here using an extension cord. So again, like the probation department's also focusing this on the attempted murder charge. And so when you take the totality of the circumstances here, look at the full transcript, our position is that this created the appearance of a violation of both double jeopardy principles and a sentence based on, in part, the personal views of the judge. And, that particular comment, sometimes that worries me that we see so much violence. It's not related to the underlying crime. It's not related to the law, to rehabilitation, the rationale for the sentence.
How can we say it wasn't related to the underlying crime? Which was shocking.
Because he's saying sometimes that worries me that we see so much violence. I think, to my read, maybe I'm wrong, but to my read, he's talking about what's happening in the community.
Well, he does see a lot of violence, and he saw a lot of it in this case. He rushed into her apartment and tried to strangle her with an electric cord, told her he was going to kill her, her children, and then himself. That's a lot of violence.
That's a lot of violence. And to the extent the judge is looking at the facts of the case, I think that's appropriate. But to the extent he's considering so much violence in the community, I think that's what creates the appearance of a problem here.
Do you think that a judge properly looks at not just the case in front of the judge, but, again, context? What did I do last week on a similar case? What did I do last year on a similar case? How is this different from a case on which I sentenced someone under, again, similar circumstances? Think that's appropriate or not? Which is not so much community, but again, cases that are in the court and trying to find a fair disposition. Think that has any role at all?
I'll say that I think it probably does. I think judges have a really hard job with sentencing. And I think it's very natural for a judge to look at what he did before. But I also think we have to look at the case law, and what the law says is you're supposed to look at the facts of this particular case and the law and apply them dispassionately as possible and to avoid all appearance of impropriety or improper consideration.
So I want to put a little different spin on Judge Brennan's question. So he was focusing on the judge trying to treat everybody equally. What about, could a judge consider trying to send a deterrent message to the community?
I think that's actually prescribed by the case law. I think the White case, I believe the White case in particular, and the Mills case might talk about this as well. Those are both cases cited in my brief. Specifically says the judge's job is not to send a message to the community. It's to sentence on the facts and the law of this case. And I think that makes sense because I think it's the legislature's job to decide, what's a crime and what's not, to decide what kind of messages to send to the community. It's not the judge's job. The judge's job is to decide that case and that case alone.
Does White talk about general deterrence? I mean, I don't know that it specifically discusses general
I'm not sure if
deterrence.
it's the White case or the Mills case, but I know that there's a case that specifically, and I can look that up for you, that specifically says that the judge's job is not to send a deterrent message to the community, and if he's doing that, that's a problem. And if there are no further questions, I'll rest on my brief.
Seeing none, thank you. Mr. Buxton.
Thank you, Your Honor. May it please the court. ADA Sean Buxton on behalf of the Commonwealth, asking that you affirm the order imposing sentence in this case. If I could just briefly address the appellant's argument regarding the guidelines, I would begin by noting the advisory nature of the guidelines, and I would just, if I could, answer Justice Brennan's question that was posed to my brother about if the judge had simply made an error in calculating the guidelines. It's Commonwealth's position that that would not be sufficient to render this sentence illegal or constitute any form of reversible error. I would just note that given the discretion allowed by the guidelines as to the various assessments, factors that can be considered, I think it's difficult, if not impossible, to know how the sentencing judge in this case arrived at that 16-month number. I would just briefly note that if the judge had been considering attempted murder, which is a level 7 offense, and had looked at the defendant's record, regardless of any decay periods, there was sufficient level 3 and 4 offenses in just the past 8 years within the decay period to say that the defendant had a serious record. And so the lower end of the guidelines for that attempted murder charge would be 84 months. So that 60-month statement wouldn't be true for attempted murder. Whether it was true for assault and battery by means of a dangerous weapon depends on how the judge calculated the defendant's record, the seriousness of the injury in this case. I would just note, as to the personal beliefs, I believe the case law is that the judge essentially would have to permit himself to become an advocate for the Commonwealth. To that point, I would just note that the defendant here was found in violation of probation on count 2, which was charging home invasion, where he faced a minimum sentence of 20 years, a maximum sentence of life in prison. The judge reasonably, I believe, decided to keep that case hanging over his head in the event of any future probation violations, and instead decided to sentence the defendant to 5 years of the 10 that he faced on the assault and battery by means of a dangerous weapon charge. If the judge had wanted to transform himself into an advocate for the Commonwealth, I would suggest that he could have gone much further, and he did not do so in this case.
Not saying that that's what the judge did here, but do you have a position on whether it is permissible for a judge to, as part of a sentence, consider a general deterrent effect, or to articulate a general deterrence reason?
I would be hesitant to contradict my brother's statement without a further review of the case law that that's not an appropriate consideration. I would note that in my review, generally the sentence is supposed to be tailored to this specific offense, which, as Justice Meade mentioned earlier, was particularly serious. So I wouldn't want to speculate on that without doing more research, Your Honor.
So would you say that the judge, when he says that worries me that we see so much violence, is looking at the case or looking at all of the cases that he sees?
If I could say my reading of it is that the judge seems to be worried that at times the amount of violence that he sees in his job desensitizes him. And to me, this is a reflection on the fact that despite that desensitization, this case still managed to shock him. And I think that was, in my view, a description of the particularly serious nature of this offense, that despite how much violence he sees on a day-to-day basis, this case still managed to sort of break through that, and he needed to take some time off, which, as Your Honors mentioned, was the appropriate course of action in this case. So, if there are no further questions, I'd rest on my brief.
Seeing none, thank you. Thank you both.
Thank you.
Our next case is 24P1030, Commonwealth versus a juvenile. This case is impounded, as you know, so do not use any names. You can use the police officer's name.
If you can pronounce it.
Kubarni. Mr. Coase.
Good morning, Your Honors. May it please the Court. My name is Matthew Coase, and I represent the juvenile. This case is about what the Commonwealth failed to prove at trial. Rather than presenting sufficient evidence supporting each of the convictions, the Commonwealth's entire case rested upon speculation, conjecture, and the piling of inference upon inference. I want to focus my argument today on the firearm, as I understand that the Commonwealth will be conceding the possession of the controlled substance.
You can begin with the gun, but we're going to talk about the cocaine.
That's fine, Your Honor. Do you want to start with?
It's your choice, but we're not avoiding it.
Okay, thank you, Your Honor. With respect to the firearm, I want to first point out that there's a major distinction between direct evidence and circumstantial evidence. I certainly recognize that a case such as this can be proven on circumstantial evidence, but I think the circumstantial evidence needs to be viewed in light of the fact that there is no supporting direct evidence. There's no direct evidence whatsoever linking the firearm to the juvenile in this case.
The Commonwealth can prove its case with circumstantial evidence, so let's look at the circumstances.
So moving on to the circumstantial evidence in this particular case, it has to also be viewed in light of the evidentiary errors that were also presented in this case.
No, actually, it doesn't. We review sufficiency of the evidence based on what has been admitted without the propriety of its admission.
So I'll start by addressing the circumstantial evidence, then I'll discuss the evidentiary errors and how they interplay. But with respect to circumstantial evidence, on page 21 of the Commonwealth's briefs, they point out 6 items that they view as being the circumstantial evidence supporting the conviction. And I would suggest that the first 2, or the record suggests that the first 2 of those deal with flight. The fact that the black Infiniti takes off when the police activate the lights and sirens, and then when the vehicle stops, the juvenile gets out of the passenger side and starts taking off and running towards the building. So the cases such as Evelyn and Warren diminish the quality of flight when looking at circumstantial evidence.
Those are reasonable suspicion cases.
Those are reasonable
They are
suspicion.
not sufficiency cases.
Well, I would say that when we look at reasonable suspicion, it's part and parcel to circumstantial evidence when viewing the case.
We have to view the evidence in the light most favorable to the Commonwealth, not the light least favorable to the Commonwealth.
I understand that, Your Honor, but
So in the sufficiency equation, flight equates to consciousness of guilt, which tips the scale in favor of sufficiency.
I would say in the circumstances where you have a black youth and they're being investigated by the Boston police, the case law suggests that that is a diminished quality with respect to flight.
That would be a great jury argument.
Moving on, the next item is the Commonwealth argues that the juvenile was holding something in its waistband. And the record does not reflect definitively that the juvenile is holding something in his waistband. I think the Commonwealth can accurately represent that the juvenile is running in a way that is not typical, but I think that's where one of the inferences come in and where the Commonwealth relies on conjecture and speculation, which I would suggest.
Let me ask you this, and it's going to bleed into your other arguments, but could the prosecutor, suppose the police officer had not mentioned that, could the prosecutor argue to the jury, look at these videos of him running. You can see he's running awkwardly. You can infer from that he's got a gun there. Is that a proper argument?
So the Commonwealth can certainly make those inferences in their argument, but reasonable inferences in argument are not actual evidence. And we're looking at the actual.
But they can make, so no problem making that argument, no problem for the jury to draw that inference. And in light of Judge Meade's initial comment, in terms of sufficiency, we also have the police officer saying that.
Well, the police officer did not make that statement based upon his own direct observation. He made that statement based upon his observation of the surveillance video.
Is this the argument about the surveillance video, or him describing what's in the surveillance video?
Well, that's part of it,
Okay.
part of the argument.
It's his body cam footage, right?
No, this is surveillance video that's taken from.
But he was there and he saw the same thing.
Well, the record demonstrates that there's a significant gap between Officer Cabarni and the juvenile. It's approximately between 9 and 11 seconds. So when the juvenile gets out of the car, if you're looking at it, it's Exhibit 2 is really the prime exhibit here, which is surveillance video. It appears to be on the building. It's looking out towards the parking lot and then the road. The juvenile gets out of the passenger side, and on the video, he's on the left side of the video, and he's running down kind of a sidewalk towards the building. Officer Kabarni actually gets out, and he goes more to the right side of the video, and you can see he runs behind appears to be maybe a chain link fence. It's some sort of opaque fence, and then he turns the corner and starts running towards the building. And there's a gap of approximately 10 seconds between when the juvenile hits the door of the building and when Officer Kabarni hits the door of the building. So I think when reviewing the record, to suggest that, that was a direct observation is not accurate. And I think
but there are cases that, from this court and the SJC, that says that you can have a witness describe, if it's helpful to the jury. And since we have surveillance video in every single case we get, and they're often difficult to understand, why was that an abuse of discretion?
Well, I don't think that the record doesn't demonstrate that this surveillance video was difficult or hard to understand for some reason. I think the cases from this court or from the SJC kind of distinguish between what a common juror could understand and something that might take a little bit more of an expertise in understanding. So in this case, on this record, it seems as though the Commonwealth tried to point something out and ask the jury to make that inference, even though that actual evidence wasn't actually in the record, but it required conjecture and speculation on that point.
I'm sorry. So on this one, I mean, isn't the way that a person that a person might be secreting a gun, isn't that actually typically the kind of stuff that police officers do testify about?
There's cases, the one that comes to mind is the Grayson case, which is a somewhat similar fact pattern. But the distinguishing factor in that case from this particular case is there was no testimony about Officer Kabarni's experience and training, about the characteristics of an armed individual. There was no observations that there was a bulge in his pants, that he was bleeding his body.
He doesn't say it was a gun, right?
He does not say there was a gun, but he says that he was holding something in his waistband or sweatshirt.
What if we
That's not an opinion on guilt then, right?
Well, in a case that centers on possession of a contraband item, he's basically testifying that he's holding something that needs to be hidden, whether it be drugs, whether it be a gun.
Is this similar to a Canty type issue in an OUI? Isn't that what you rely on?
I believe Canty is a case that involves intoxication and in a lay opinion.
The police officer improperly says they're driving under the influence of alcohol instead of just saying that they were affected by the alcohol, they're impaired by the alcohol. But the line. What I'm getting at is the line they draw is quite strict. They being the folks on the second floor. That you have to say, I thought he was guilty of OUI, or he was guilty of illegally possessing a gun in this case, but none of that occurred.
With respect to the ultimate opinion, I would suggest that the combination of the statement by the police officer combined with the inference made by the prosecutor at both opening statement and closing statement would rise to that level. But I think the stronger argument here in this case is that it invaded the province of the jury to make that determination. Again, Kabarni was not in a better position as it related to reviewing surveillance video.
Just take then the following evidence. The juvenile runs into the building, runs up the stairs. There's a noise of some sort from the third floor. Police go up to the third floor, and sitting right there on the windowsill is a gun. Okay? Distinguish that from Jefferson, which the Commonwealth cites, where the SAC said, well, you got enough there because it's in plain view that you would expect that it wouldn't have been there long, and you get a noise to associate it, and a person's running. at least a rational juror in the light most favorable to the Commonwealth could draw that inference that the juvenile left the gun there. Why is this different?
Well, I think the fact pattern that you're describing is different than the fact pattern that's in the record. The juvenile was found on the 6th floor, not on the 3rd floor.
Right, but there was testimony that as he's running up, the officer hears some sort of noise on the 3rd floor.
He says approximately the 3rd floor.
Okay, fair enough.
And we don't even know for certain that the juvenile ran up the stairs.
That's where the gun was found, on the 3rd
Pardon?
floor. The gun was found on the 3rd floor.
The gun was found on the 3rd floor, but the officer is presupposing that the juvenile was on the stairway. There's no evidence that he was actually on the stairway as well. So I think this case is a little bit different from Jefferson as well. I think, if I'm not mistaken, Jefferson is a case that involves the revolver being thrown out the window of the vehicle. And in that case, the car window had been open. There was broken pieces of the revolver found on the road or the sidewalk. So I think that inference is stronger than in this particular fact pattern where, there's a break in the flight pattern. There's really no connection between the juvenile and the 3rd floor other than the officer's assumption.
Can you address the sufficiency on the cocaine now, please?
So with respect to the sufficiency on the cocaine, I think it's very limited. The testimony on the record is limited to Officer Langton's testimony, which I believe is 56 and 57 of the trial testimony. And essentially what she says is that she was responsible for searching the juvenile after he had been arrested. He was in the booking, they searched the jacket, and inside the jacket they found a small plastic bag containing what was believed or ultimately determined to be crack cocaine.
Where did the jacket come from?
Well, on
Some random person that you said. It's not some random jacket, right?
On cross-examination, the Officer Langton concedes that the jacket was put on him because it was a cold
Where did the
March
jacket
night.
come from, Mr. Coase?
It's not clear from the testimony of Officer Langton. The Commonwealth is arguing, or did argue in its brief, that it came from Exhibit 10, which was the body-worn camera of...
You omit this in your brief, that it came from the bedroom that had the Air Jordan logo on the door in the two-bedroom, two-bed house that two people lived in.
Right, so if the court does consider Exhibit 10, I suggested that it shouldn't.
No, I want to consider the Air Jordan logo that you failed to mention in your brief.
Why
Why isn't it a fair inference that that belongs to the young man,
when
opposed to his mother?
When you watch the body-worn camera footage, the record reflects that there's posters throughout the apartment. In the common area of the apartment, there's a Grand Theft Auto poster, which would suggest, just as suggested as an Air Jordan logo, that's where the juvenile stuff
Was it
might be
on a
stored.
bedroom door?
No, but it's in a common area where
Is that where the
personal
jacket came from,
No, the item came from the room.
with the Air Jordan logo on it?
Right. I think also a reasonable inference is that other people were living in the apartment. The juvenile could have had a sibling who
The Commonwealth
hadn't.
doesn't have to exclude hypotheses of innocence in a sufficiency case.
Well, the evidence is that the inferences that the Commonwealth needs to provide have to be reasonable. And I think that that's not a reasonable inference to suggest that only
That the blue puffer coat that came from the bedroom with the Air Jordan logo is not reasonable for the fact finder to conclude that that belonged to the 14-year-old as opposed to his mother. Why is that unreasonable?
Well, first of all, the jury never saw that video.
I'm not talking about the video.
Well, then it's not in evidence apart from...
There's no evidence of the Air Jordan logo?
There's no evidence of the Air Jordan logo except for the body-worn camera, which was Exhibit 10 and was never showed to the jury. So if you extract Exhibit 10, the only evidence of the cocaine is Officer Langton's testimony, who talks about putting a jacket on the juvenile
Right?
after his arrest.
No officer testifies about who lives in the building or how many people live in the building or where the rooms are or where the jacket came from even. right?
No,
There's no testimony at all about that.
There's no testimony about that. There's some testimony about how many apartments might be in the building, how many floors might be in the building. I believe Detective Diaz testified about that. There might have been some testimony from Officer Kubarni.
All right, thank you, Mr. Coase.
right.
Very helpful.
Thank you.
Ms. Morris.
May it please the court, ADA Bryn Morris.
The only evidence of the Air Jordan logo was on Exhibit 10?
It was on Exhibit 10, and based on the Commonwealth's review of the evidence, defendant is correct that that portion of Exhibit 10 was never played to the jury and did not reach the jury.
Is it Langton? There's no testimony describing?
The testimony of where the jacket was found is that it was found in the apartment, and that's it. And that's the entirety of the testimony that reached the jury, which is why the Commonwealth is conceding that the defendant did not, or that it would not prove sufficient.
Actually, it just says a jacket was found for him to bring. That's all it says. That's the entirety of it.
Yes. And so for that reason, we're conceding on the sufficiency. There is, however, sufficient evidence of the firearm. I mean, here we have consciousness of guilt evidence. We have the video evidence showing the defendant holding something at his waist. We have the fact that the door was heard on the, closed on the third floor, and that the firearm was seen on the third floor, and we also have the emptiness of the apartment.
What do you think the impact, if any, of the shots fired testimony was, without any limiting instruction, on the juror's inference that maybe what he had, if he was running funny, was a gun?
On the sufficiency analysis, the jurors can properly consider that both that the police officers were responding to a call for shots fired and that they suspected the black Infiniti vehicle was involved on the sufficiency analysis.
Even if it was improperly admitted?
Yes, it's the Commonwealth's position that that was not necessary to the sufficiency analysis, looking at the other factors, but the jury is certainly permitted to consider that. I want to talk about the consciousness of guilt evidence, because this isn't just somebody was running from a police officer. This is the driver of the black Infiniti sped off and engaged in a vehicle chase until the passenger was able to exit the vehicle and run away, at which point the driver was calmly arrested, which is a remarkable change in the driver's behavior in terms of evading the police. And then you have the juvenile sprinting off. You have video evidence of him holding something at his waist or his sweatshirt area.
Was there evidence that the officer could actually see that? Or was it just the officer saying, folks, what you're looking at is, and then describing what's on the video?
So the testimony is not clear one way or the other, because there was a discussion at sidebar about whether the officer was testifying to what he was seeing in the video or what he had seen in person, and then neither attorney asked any clarifying questions to clarify which he was referring to. But regardless of whether he was referring to the video or whether he was referring to what he had seen, I mean, it's obviously proper if he was referring to what he had seen, but if he was referring to the video, that was still properly admitted, because his testimony was very limited on that point. It was just calling the jury's attention to one thing that is clearly visible on the video, that a lay observer seeing a video for a first time might not immediately catch on, but certainly proper for an attorney to argue in closing that the jury should be looking at that particular point. And so it was really just providing, look at this point, jurors, and make your own assessment. That testimony was very limited. Back to the sufficiency, I want to also talk about the fact of where the firearm was found, because I think that's actually quite compelling in this case. The firearm was found in a place where Detective Diaz's partner could see it right after exiting the stairwell off the third floor, and it was found in a very obvious location. Not only were there no people around, but it is highly unusual for somebody to leave a firearm on a windowsill in plain view in a public space. That's the kind of thing that you wouldn't, like, somebody would not leave a firearm there to retrieve it later. If they had enough time to dispose of an incriminating firearm, that's not a reasonable location to pick. And it's not a location where a firearm would stay very long because it is such a public area, being a corridor in an apartment building. So for those reasons, combined with the fact that the officers did not see anyone else around at that time, it's very reasonable for the jurors to infer that that firearm, which was discarded kind of in the juvenile's possible path of flight, was discarded by the juvenile.
What was the evidence of the juvenile's path of flight? Just that he went in the building and then he ended up on the 6th floor?
Yes, Your Honor. So
Was there any evidence as to whether there's an elevator in the building or how many sets of staircases there might be? Or?
there's no evidence as to either of those facts directly, but what there is evidence of is the type of building that it is. The jurors were able to see about 11 minutes of the body cam footage showing the officer's path in the staircase. So first off, they know that the officer chased the juvenile and went into the same door that the juvenile went into in the apartment building. They also know that, based on his testimony, that as part of his path of flight, he was going up the staircase, and then around.
I just don't remember, right, maybe I couldn't open it. But is that body worn in?
So the body-worn camera starts around the 4th floor-ish of the staircase from the officer's pursuit. So
it doesn't show the door that he went in?
The surveillance video is where you see where the juvenile and the officer.
But to the extent that you can see once you walk in the door, am I looking at stairs over here, stairs over there, an elevator in the middle? There's nothing in the record on that?
No, Your Honor, but based on the officer's testimony, I think it's clear that he went into that door and followed
The noise he heard was in the staircase.
Yes, while he was in the staircase, he heard a noise heard a door close on the 3rd floor, is what he said, or what he testified to.
So is what you're saying is that it was not a door closing, but it was the juvenile placing the gun?
No, Your Honor. So to get from the stairwell to where the gun was placed, you would have to exit a door to get onto the 3rd floor, out of the stairwell area.
Oh,
so I think
the gun was found outside of the stairwell?
Yes, Your Honor. So I think the reasonable inference is that what he was hearing is the defendant exiting the stairwell to go to place the firearm. And how the juvenile got from that place to the 6th floor is not testified to because there wasn't any direct observation. But I think a reasonable juror who is familiar with living in Boston and apartments that are about as new as the apartment building they were seeing there can infer that there's going to be multiple staircases at least to get to the 6th floor, even though there is no direct testimony on that. They could also have inferred based on the testimony that the juvenile returned, because the testimony was that where the firearm was found is within the line of sight, basically from right after you get onto the 3rd floor off the stairwell, so they also could have inferred that he returned to the stairwell and returned to the 6th floor from there.
So moving again back to the shots fired testimony, why was that more probative than it was unfairly prejudicial?
So in this case, without understanding why the police officers were responding the way they were responding, it just seems incredibly overblown because when the officers arrest the 14-year-old, they have their firearms pointed at him. And despite the fact that, he has his hands raised above his head. That is an enormous show of force that would seem very out of place for just somebody evading the police.
That wasn't the argument that was made at trial. You made a very good argument, compelling argument, it seems to me, on appeal on that, but that's not the reason that the trial prosecutor offered, right? I think they said, well, just the reason why they stopped the car. Pretty sure.
Yes, but I think that that's the same concept, Your Honor, explaining why the police were doing what they're doing. But in any event, you can affirm the trial judge's rulings for any reason apparent on the record. And this is, I think that's the reason they stopped the car is in some ways a shorthand for that's the reason police did what they did. And it's...
Okay.
it's well within the realms
I
of,
agree that it's not unreasonable for a juror sitting there to say, well, did he toss the gun on the windowsill, or was he, how long was he there? And then someone else saying, well, I mean, they were going for a shots fired call, so obviously, no kidding, put the two together. That's evidence that he had the gun.
so I think that what you're getting to now is whether or not that the admission of that testimony without a limiting instruction created error. And
Right, because it was unduly prejudicial.
reversible error. And the reason why it didn't is because that testimony was incredibly limited. It was just that that's what they responded to and that they had some evidence that a black infinity was involved. There was no further testimony about suspecting the juvenile or about the firearm being found being used in the shooting or anything like that. And in light of the other evidence towards the sufficiency of the evidence, that was not reversible error because it's the juvenile's behavior that the consciousness of guilt evidence combined with the location of the firearm, as well as nobody being present, that is really the compelling circumstances in the case here.
Can I say a slightly off the record maybe question, which is, how did the jury not get to see that exhibit?
Exhibit 10?
On the drugs. What happened there? Did they did not go in with
So
them, or did they?
What happened is
couldn't
the
open it?
trial prosecutor did not believe that most of Exhibit 10 was relevant to the case that he was proving. The portion he thought was relevant was showing the juvenile's hairstyle on a clearer picture so that you could compare that to the surveillance video. So
even though it was marked as an exhibit,
it was marked and apparently admitted as an exhibit,
Right.
but the agreement, or the
it
agreement
just
that
sat
the
in the clerk's
prosecutor
desk, or we don't know. Okay, but it
agreed
didn't
to
get to
was-
the jury room. Okay.
Yeah. So a couple witnesses after it's admitted, the judge says on the record that to the jury that he's not going to be sending the body cam back with them. So it's unusual, but it is what happened here, and defense counsel is correct.
Can I ask about the commenting on the video footage? So you have, there's two different, there's the body camera, which is this officer's body camera, but then there's the surveillance video, which is not his.
Yes.
And, I mean, it seems to me, I mean, this is going to happen, this is happening more and more in all the cases. All this stuff comes in. And I see that if the officer is actually describing what the officer was doing, that, this shows what I was doing, that's one thing. But just general commentary on other video, that's more into the pleas type of analysis, right? Or
So typically, I mean, an officer can have knowledge kind of outside of what's immediately apparent to the jury when viewing surveillance footage, regardless of whether or not it's showing their actions. Here, I'll note the officer was describing, when he was watching the surveillance video with the jury, he was describing, yes, that's me, that is the chase I engaged in, and that kind of commentary. But even in other circumstances where an officer isn't familiar with or wasn't present at the actual scene, they can still describe, I'm familiar with this area where the video was taken, and describe things that they see in the video. They can also sometimes describe things that they noticed because they've watched the video many
So that's my
times.
question. I guess maybe to pick up on Justice Massing's question, isn't there a material difference between the officer saying, well, I saw him go into the building and he was holding his hands kind of funny. Oh, and on the video, that's what I was talking about, that right there. That's just to draw the jury's attention, as opposed to, let's all watch a video that no one's ever seen before and say, oh, I think right there he's holding his hand kind of funny. There's a difference. One, it seems, is pretty clearly okay, and the other one, I'm not quite so sure, unless we just give the jurors a little bit of credit for being able to figure out things for themselves.
So, Your Honor, I think the line is what the officer is testifying to. It really is exactly what he's saying. When the officer is giving testimony, which I think is what happened here, where it's, look at this behavior, notice this behavior, I think that's proper. Where it gets into the more speculative, like if the officer had testified, look at this behavior, that's a firearm, that would have crossed the line, because that's inviting something, I think, beyond what the officer can actually just call the jury's attention to, and but that's not what happened here. Here, it was just notice this behavior, and I think notice this behavior is a proper way of a lay witness to help assist the jury with viewing the evidence and still encouraging them to draw their own conclusions from that behavior.
The reason that Kurbani knew and recognized the juvenile, that came in the voir dire, not at trial, right?
That's correct, Your Honor. Yes. If there are no further questions.
Seeing none, thank you. Thank you
you.
both. The next case is 25P603, SH versus HO. This case, too, is impounded, so please do not use any names. Ms. Stuntz?
That's correct. May it please the court, my name is Karen Stuntz, and I represent the appellant mother in this case. Good morning, Your Honors. This case is this is a removal case where father requested to remove the minor child from the state of Massachusetts, where he had always resided, to the state of Texas. And when you look at the court's findings, we are asking the court to reverse this decision in part. When you look at the court's own findings, you can see that the court made significant findings about father's what I would call bad behavior, alienating behavior, which the court actually uses that term in its findings of fact, an inability to co-parent, and a refusal to adhere to a prior judgment. The court allowed father to remove the minor child to the state of Texas. And I would specifically note, Your Honors, if you would, to call attention to what the court says is that the father was likely to use the distance as another, she uses the word as another, tool to impede mother's parenting time, thus providing a roadmap of what was to come. So in this case, we would argue that the court made significant findings as to father's behavior, and I would suggest insignificant findings as to what she calls mother's, that mother's temper hadn't cooled as to father.
Suppose the judge actually even just made that finding that the father has obstructed in some way the mother's access to the child, right? Let's assume that. But at the same time, also found the father has a sincere motive for moving, there's an advantage to the father, and that the move is in the child's best interest. Couldn't the judge still do what the judge did here?
Well, I would say no, Your Honor, because I do not think that the evidence supported that there was a sincere effort or sincere motive to move, and here's why. Father filed this complaint for modification 2 months after being found in contempt by Judge Rivers for denying mother over a month of parenting time during COVID. And if you'll recall, there are...
Can I just stop you for a second?
Sure.
I'm not going to dispute that recitation of the evidence. My question is, why is it not within the judge's discretion, even if the judge found that the father was obstructionist and difficult and depriving the mother of things, to also find that other things and then to weigh the two and say, okay, when I weigh it, the weight of these 3 factors outweighs whatever steps the father has taken, even somewhat recently, to frustrate the mother's access here? Why, well, as a matter of law, could the judge not do that?
As a matter of law, so if the court found that there was a sincere motive to move, that father had, in his complaint for modification, he pleads that he had an opportunity for employment in Texas. So at the time of the trial, that was not present. He testified that he didn't have a job. He testified he didn't look for a job.
But I thought, does the real advantage attach itself to actual employment or the real advantage to find employment in this field?
Well, I think the case law speaks about cases where there was an employment opportunity. For example, the case where the father was already employed in a Florida law firm. But in this case, I think the speculation is what I would say is different in this case, in that Father hadn't even looked for a job in many years. He offered no evidence by way of any vocational expert. He offered no evidence by way of any jobs that were available. There was no documentation entered.
He says he didn't look for a job because he had gotten jobs and said no, and he couldn't just keep getting job offers and rejecting them until, essentially until somebody cleared him to go with his kid. What was the point, right?
Well,
And the judge credited that.
She did, and I would say, but interestingly enough in this case, he filed a motion for temporary removal when he did have a job, and it was through Mohami, which was a remote position that was actually, I think he testified, a connection with his brother, California company. So at that time, he did, and so he had secured a job, so I would say it contradicts his then testimony.
But then they withdrew the offer of full-time employment when they found out he couldn't move.
I think that was his testimony.
Well, and the judge credited it.
The judge did credit it, but I don't think there was.
You say that the child had a great relationship with the aunts, with maternal aunts. The only evidence of that is the mother's testimony.
It is the only evidence.
Why,
but,
you want us to believe her, but not believe him? But that's the judge, not us, right?
Well, but I think that in this case specifically, there was so much conflicting evidence that I think and I think you have to look at what the judge, so for example, she says that father didn't bring the child to certain school events because he was afraid of the conflict. Where we have specific instances where father put himself in the middle of conflict with the child there, such as those police incidences where they had to go to his door, the child was there, he got into an aggressive altercation with the police, was recording it, and tried to evade the police by leaving down an alternate exit, all in front of the child. Secondarily, the 209A that father obtained right before the trial of this matter, he actually waited to tell mother that he had obtained the 209A until she was at the school where their son went to school and was being released. And so again, there's another instance where father is putting the three of them in the same conflict.
Did the judge ignore that?
I think so. I think so.
Aren't those findings in her findings?
Well, the findings are somewhat, I don't think they're accurate to a certain extent, because the judge says that DCF instructed him to do so, and that's not accurate. That's not part of the record. What DCF indicated, and they didn't know at the time that father had an upcoming modification trial, but they indicated that he should go and suspend visits, not obtain a 209A restraining order. And the court actually points out that she didn't find that appropriate based on what had happened. And she also discredits father by saying he went to the courthouse following mother because he was trying to see about the correction of the time on the restraining order. So the court actually points out that she discredits him. And I think when you take all of the times that she has discredited father and his testimony, and you look at the evidence that was omitted, that is part of the record, where he's intimidating school officials, he's taking the child out of school after mother's had contact with the school, where he's taking these active steps to prevent mother's parenting time. And basically the court says, well, I don't have an option in this case because neither parent is appropriate. But what she relies on inappropriately, I think, is that she goes back to 2018. So there's very little findings about the best interests of the child, if you even get to the real advantage of father, between 2018 and the time of the trial, such as his relationship with his mother, because she discredits the entire GAL report, even though she does note in her findings, again, contradictorily, that I credit the GAL in this instance, I credit the GAL in this instance, but then she says I give no weight to the GAL's report. And so what I find myself is when I read these findings, it does not lend itself when she's actually pointing out that this father has taken active steps to prevent mother's parenting time, to alienate mother from this child, to put himself in conflict with the mother, that to remove this child to the state of Texas and go back to the same parenting plan that the father had over a decade ago is appropriate based on the evidence that was in front of her. And she didn't weigh the GAL report, but I think it's a stretch to say that she gave it no weight, and so everything in the GAL report, the child's interviews, the interviews with the parents, the interviews with the school, would be given 0 weight, and that she would essentially say that based on the 2018 judgment, you know, I'm going to look at things now for father, but I'm not going to look at things now for mother. And certainly there can be a change in circumstances between 2018 and the time that this case was tried in 2024. And I think there's numerous examples of that throughout that. I think the court also has little findings about the best interests of the child, the 5 factors, whether his quality of life will improve. There was no documentation as to the school he would be attending other than father's testimony. There was no documentation relative to any specific courses that they had. The father didn't introduce any of that. It was only his testimony as to where he would enroll this child. There was no other documentation of what extracurriculars or anything of that nature he would be enrolled in. The court also noted father didn't introduce, although I wouldn't say she says father didn't introduce, but there was no evidence of the cost of travel to and from Massachusetts to Texas. And I think that that was father's burden to introduce those costs, to meet that burden, to say that it was his request to remove this child. If you look at the record, part of Judge Dunn's findings in 2015 were that the father was trying to initiate proceedings in Texas, say that the child's birth state was Texas, even though the child had never resided in Texas. And I would submit to you, and mother would say that this is a long-standing campaign of father to get to the point. I mean, I think that his filing of the complaint for modification to say, all of a sudden I have these opportunities in Texas 2 months after he was found in contempt by the same judge. I will also note, in his complaint for modification, he seeks to eliminate the judge's ruling on that complaint for contempt and to deny the court's ruling that she be granted 14 days of makeup time. And you can see that the record is replete between his correspondence with the school, his failure to tell mother basic things such as the therapist's name, relying on the fact that the therapist was not a medical provider and he didn't have to give her this information. Again, all things that the court, again, said.
The judge found him in contempt on that one.
She did find him in contempt on that one. And I would say that the contempt that she also noted that she didn't know that there was no definition of summary per the 2018 judgment, and so she couldn't find him in contempt. And I think the record is replete with that this child had medical issues and father was merely saying he had a medical appointment.
Can I ask you, you mentioned a few things that you say the judge didn't consider. You mentioned one error about DCF instructing him to take it to an IA. Are there any other errors of fact in the judge's findings?
I would say there is a lot that was omitted in terms of that. I would say that there was one error, to answer your question, is that there was no document from the school to suggest that mother's contact with the school was inappropriate. In fact, quite the opposite. The school indicated that they found mother's contact to be engaging and that it wasn't affecting him academically. What they actually had the problem with was father, in the instance where he removed a child from school after the child waved to the mother, and he attacked a teacher. He actually emailed, and then he went to the school and said, "You are not to allow or prompt my son to wave to his mother, you know, essentially mind your own business."
Where did the concern about how the child was dropped off at high school come from?
Father made,
School as well?
I'm sorry?
Didn't that come from someone at the school as well?
No, so father during the trial made the argument that it was inappropriate for mother to walk the child to the front door.
Right, holding the hand until he
Yeah,
walked
and
to the front door
so
of the high school.
what interestingly came into evidence during mother's cross-examination by father's own counsel was a photograph, and in that photograph, father is holding the child's hand. And father would submit to you that he was much younger, but I think the photograph speaks for itself. And in fact, I I then later redirected my client on that point, that the very nature of what he was saying was in fact what he was doing himself. And we find this instance with the birthday party. So there's documentary evidence in the record that he admitted he wrote a letter to the GAL, and nowhere in that letter to the GAL does he talk about this alleged incident where mother grabbed the son, as he testified to at the trial, during the birthday party. And this is an error, I think, of the court's findings. The court didn't seem to note that in her findings. She said she didn't know who to believe. But there are documents to suggest that father was making up that testimony at trial because that's in fact what mother was arguing. But mother had an email, and she had sent an email to father contemporaneous with that instance. And then he spun it around to say, this is what's happening when I was there. And I think the court made an error of judgment based on the fact that there was actually documentation that despite him testifying to that, he never brought it up to the GAL. He never wrote it in his letter. There was never anything about it until the time of trial when he then brought it up. And for all those reasons, I'll rely on the rest of our brief and ask that you reverse the lower court's findings.
Thank you.
Thank you very much.
May it please the court, if you actually read my brief, you'll see I spent maybe like 20% of the space to debunk alleged facts they presented. So I ask you to not take our presentations about facts of the case at face value. What she presented now is inaccurate. We have the benefit of having the record, and we can always refer to it. And if she makes statements now, oh, this was how it really was, I have no way to actually respond to that right now. I think she had the chance in her brief. I responded to that. There was no more response to the facts because I did it diligently. She used her reply brief to rehash her old argument. So especially regarding this alleged alienation, there's a lot of fluff, a lot of embellishment in there.
Could you tell me, based on the evidence that was submitted at the trial, what evidence at trial is there of the advantage for your son of going to school and living in Texas, besides your possibility of making more money?
Of going to what? Going to
What are the advantages of him living in Texas as opposed to Massachusetts?
Okay, there are actually three advantages. One was higher income. Then, hasn't been talked about a lot, but I think that's a huge deal. That's what the judge called superior living arrangements. And
You're talking about bigger home? Is that a bigger home?
Superior living arrangements,
Yeah, okay.
and that rent-free. You can assign a number to that. You can look at how much they pay for rent, how much income they make, what percentage would that be. But I would suggest that alone would be reason to move to Texas, having a place.
Do you have a job in Texas?
Sorry?
Do you have a job in Texas?
When?
Now?
No, yes, I do.
Okay.
And regarding the job, the case was filed.
I'm sorry, is it a job in your field of study?
Yes.
Okay.
The case was filed 5 years ago, dragged on 5 years ago. If you look at the docket, you see hearing was postponed, and then trial was canceled, reset, and so on. If you were to make a standard, you have to have a job offer at the time of trial. You probably would have to have a job offer at the time of the evidentiary hearing, at the time of the GL investigation, at the time of filing the case. You would have to have like 5, 10 different job offers in a row, and no job, no removal would ever be granted.
So I understand that. We have to, we do have to focus on what was before the judge at the time. So she,
Yes.
she didn't know at the time, though. I mean, you're explaining why you didn't have evidence at the time that you had a job offer. What about, back to my question, superior living arrangement? What about the school? And what was the evidence at trial about the school?
I submitted a number of documents regarding ad litem, but then in the end, about superior schools, school rankings and so on, in the end, the judge did not credit the GL's report, so that was all gone. So she had my testimony. I testified about comparing schools. I testified about certain courses. which are available there. For example, I have German ancestry. He can take German there. They have courses for medicine students. I testified about average SAT scores, about higher courses. And I'd also like to suggest to you that the standard actually, if you look at Abbott versus Viruso, there was a claim that Massachusetts had better schools as opposed to Boca Raton. And the appeals court found even if the judge had made such findings, they would not compel the conclusion that Boca Raton school system is not appropriate to the child's needs. And a note, the finding that Newton schools are superior does not compel the conclusion that Tucson schools are not appropriate to the son's needs. So the standard is just having appropriate schools. So from legal standard, that's note 12. It was also cited in other cases like Rosenwasser versus Rosenwasser, that specific note 12, which I just read to you. So I don't think there's a requirement to say more. And the judge did more. She did list a number of positive characteristics of the school system.
So what town in Texas are we talking about?
That's in Greater Houston. In town is called, it's
outside of Houston?
It's a suburb of Houston.
Okay. There are direct flights. Was there any testimony about how hard it is or easy it is to get from Massachusetts to Houston?
There was, I should say, I understand the trial strategy. She didn't want to make it a case. She didn't want to bring it up. She didn't argue it, but evidence was entered. You can look at Exhibit 118. That's in Record Appendix 8, page 123. That was entered into evidence. We also have 6 exhibits of subpoena travel documents from 6 airlines. That's exhibits 88 to 93 with flight cost, with how long the flight takes. I understand her strategy in trial. She didn't want to make it how long is it doable, is the cost effective? She didn't bring it up. But the judge had this evidence. I understand the judge too. If there was never an argument made that she can't travel, that it's too expensive, then she just made very rough findings on that, okay. But the judge had this information in front of her. Regarding yeah, the therapist, I want to say one word. You know, there was DCF involvement. DCF recommended he goes to the therapist for trauma caused to him by mother. So I did not feel it appropriate for mom to go to the therapist and get information if it's related to trauma caused to the child by mom. And I didn't appeal this contempt. I come from a family of doctors, and I know, you know, a therapist is not a medical provider, can't prescribe anything. But okay, the judge found contempt. It is as it is. Regarding alleged alienation, it has been very vague. If you look at the facts, looking at 2020, half a decade ago, during unprecedented pandemic, she lost 2 weekend visits and a handful of Tuesday afternoon visits. There was never before a court order visit which was denied to her. There was never after a court order visit which was denied to her. In addition, there was 1 visit suspended by court judgment. That was when DCF had made a finding on substantiated concern against mother. So I don't find this stretch or we're far away from abuse of discretion. If the judge did not follow her argument, oh, well, that means she won't be able to see Ibrahim again if I move to Texas. She also got full makeup time for these visits. And really, one thing I don't want to fall through the cracks is this DCF report. The judge summarized it very briefly, but I think it has weight regarding she found mother is clingy and enmeshed. If you actually read it, it's impounded, so I don't have it the exact page number of the 51B, but the exhibit is in Appendix 1, page 124. If you go to page 4 and 5, that's the first interview of Ibrahim. And if you actually read that, it will give some life to this finding of being enmeshed, because that's basically the main thing what the judge decided on. She said, okay, well, mom, child are clinging and enmeshed. In this case, it's actually somewhat positive to put a little distance between the two, right? Her interactions with third parties, providers, have been counterproductive. Her interactions with a child are clinging and enmeshed. Parents, when they meet, there's conflict or accusations. So a little bit of separation is actually good in this case. And if you read this here, you're
Can I
going
ask you just one of the main points that the mother makes in her brief is the judge definitely found that you have not facilitated the relationship between the son and the mother. I mean, there's plenty of findings that she was concerned that Texas might actually give you another tool to do that. But the judge also found that you sincerely wanted to move to Texas for your employment possibilities and not, I guess, despite that. So I don't know, how do you see the difference between, your actual, your good reasons for moving to Texas and your potential bad reasons?
Well, so first of all, I'd like to point out that for 3 years, I lived in Texas at the same location essentially when mom had custody. So clearly,
Yeah.
I mean, there are reasons
Well, no,
for
what
me
about now?
to live
What about
there.
now?
Independent. Sorry?
What about now?
Yeah, and what about, so, I mean, the reasons haven't changed, right? It was employment, it was family support, so that's why I lived there. And so these were the reasons then, these are the reasons now. And, about the relationship with her, yes, it is difficult, but again, I'd like to go back to this enmeshment. If you read this 51B report, you see mom gets jealous about having friends. Mom gets jealous about he directing his love to his pet turtle, then she tortured it and kills it.
Please don't use any names.
And so so she can't separate from him. That includes eating with me. So I can never do anything right. So there's bound to be conflict if she can't take it that he loves me. If she can take it that isn't with her, is that he's with me. So yes, there's conflict, but moving to Texas, that's a whole different thing. And alienation. Is there anything? Has been pretty broad. Is there anything about the alienation which you want to ask about? Any of the other issues specifically? Because it's been pretty broad, pretty generic. And one thing that was brought up was the school. He was during COVID in the Catholic school. That's because I was looking for something in person, so he was bound to be withdrawn. If you look at Exhibit 5, page 360, in February, I signed a paper with the school. He wasn't going to be returning to school because schools were in person again, public schools. I wanted to move him back anyway. And then I postponed that because GAL was on the case and didn't want to have disruption in there. So it's not like he was bound to be taken out of the school anyway. I understand the judge made findings. Okay, it was related to interaction between me and his mother. I understand that. I understand how she comes to that conclusion. But even if so, it would have been just a matter of months at most. Also, I don't think the judge she was trying to make it a case of, okay, he has custody, he is at fault because he did this, he withdrew him. I think the judge saw it more like, okay, what's best for the child? I'm not going to play blame game here. And for the child, it's best, okay, put a little bit of distance there, put a little bit of separation in here, and that's actually good for the child. I mean, she would have liked to have some positive findings on her. She spent the whole 8 days throwing dirt at me, I would say. She could have used some time to point out something good about the relationship with the child, something good activity. But you compare, read the DCF report, page 4 or 5, what Ibrahim said, and compare it to a case like Murray, where the father or the non-custodial parent, he was actively involved in terms of with activities, coaching the child, and so on. What does it say further back in the GL report? I don't want to even have my mom to watch me because she treats me like a baby, she embarrasses me. And Murray, okay, the kids like to be with the dad. He says he's never had a good time with mom. And Murray, they do lots of activities, go skiing and so on. He says, oh, well, my last good visit was in October. That was more than 6 months ago. So it's, right, in Murray, there were reasons to keep the kid close to non-custodial parent. She didn't give the judge too many reasons. It was all about how I'm in 8 days, how I'm in the bad guy, right? Okay. Any other questions?
No, thank you. Thank you both. Take it under advisement. We're going to take a short recess.
Court is in session. Please be seated.
Pardon me. The next case is 25P675 Jordan versus CEA Group Incorporated. Mr. Negretti, did I say it correctly?
You did, Your Honor.
Oh, thank you.
Very good, thank you.
Second time I was right today.
Again, thank you, Your Honor, and may it please the Court, and good morning. My name is Chris Negretti, and I represent the defendants, CEA Group and CEA South Coast LLC in this case. I'll just refer to them as collectively as CEA for ease of reference. The primary issue in this case is whether an answer to an amended complaint and with a cross-claim replaces and supersedes claims asserted in a previously filed and answered third-party complaint. The Superior Court answered that question in the affirmative, and CEA requests that this Court reverse the Superior Court and answer that question in the negative. In this case, plaintiff filed a complaint against CEA, which is a property owner, asserting claims arising out of a fall from a loading dock. CEA then filed a third-party complaint against the appellee in this case, Perlwitz Chilinsky Associates, who I'll refer to as PCA, because it designed the loading dock.
Just sorry to cut you off there. I think we pretty much have the procedure, I hope. But is it fair to say that there is no case that you could find state or federal that's on point? Because with my B- research skills, I couldn't find one, and my clerk with her A+ still couldn't find one.
That's correct, Your Honor. And if there had been a case
The
that was...
Fireside Motors case really doesn't say anything about this, just says, which is obvious, it seems, in retrospect, that if you settle a case, you can still seek indemnification. It doesn't talk about substitute complaints or waiver, right?
That's correct, Your
In
Honor.
the case, it seems that your opponent there cites, at least there's maybe analogous, but it's still not the same, right?
Well, I would argue that they're not even analogous. I would argue that they're...
Talk to me why it's not even analogous.
Well, the issue in those, and I believe it's the two cases, we have the National Construction Company versus the National Grange Mutual Insurance Company
To the
case.
actual published case, I would think, probably, which is national construction.
The National Construction case is, in that case held essentially that an amended complaint superseded an original complaint. So it was a like-for-like situation. And, excuse me, and as litigators, that's something we all kind of understand. You know, we understand that an amended complaint replaces and supersedes an original complaint.
So you filed. We know you filed third-party complaint, alleged 3 different claims against the two then third-party defendants. They're impleaded in. Then the plaintiff goes directly against them in the second amended complaint. You file an answer in which you make a cross-claim of just one of the 3. So if your third-party complaint was still viable, you wouldn't need to do that at all. Why can't we infer that you're dropping 2 and just keeping the 1?
Well, the issue is that we felt that we did not need to assert those claims in a cross-claim.
Why did you need to assert the contribution one then?
We felt that it was simply appropriate in that case because it was tacked on as essentially as it follows from the plaintiff's claim. It's derivative of the plaintiff's claim. So at that point, we felt it was appropriate to assert that claim and not necessarily the claims for indemnification and breach of contract, which we felt are frankly more independent as they assert additional facts that are not necessarily part and parcel of the plaintiff's complaint.
And in the joint pretrial memorandum, you seem to sort of take the position that you sort of align yourself with the third-party defendants, that you argue that there was no problem here. It was the plaintiff's own fault for backing in the wrong way, and it was. So it seems like that's consistent with no longer going against them but being with them.
Well, there was some consistency with the defenses, certainly, but also in the joint pretrial memorandum, we noted specifically our defense that we relied upon PCA as the architect in this case to provide a design that complied with codes. And we believe that the loading dock was code compliant. However, the jury may have had a different viewpoint on that, in which case then our third-party claims become, for breach of contract and indemnification, become viable. So yes, we're sort of aligned on the issue of no negligence, but to the extent that a jury assumes otherwise, holds otherwise, our indemnification claim, our breach of contract claim, follows and becomes effective at that point as a defense to that matter.
And can I just, your indemnification claims, we're talking about the PCA right now. We're focusing on PCA here. You've got an actual contractual indemnity agreement with Callahan, but your indemnity from the architect is a common law claim. Is that right?
It's a common law claim.
Okay.
That's
So
correct.
you don't have a specific provision with
Well, we have a contract, but the contract does not include specific indemnification language. So that was the issue. That was the difference with, that's why the Callahan situation is a bit different than the PCA
Right. I mean, I'm thinking
situation.
your cause of action against Callahan hasn't even accrued yet.
I'm sorry, Callahan's
Cause of
not-
action against Callahan for indemnity hasn't even accrued yet because you haven't been asked to pay anything yet.
That's correct.
But the one against the architect would accrue when they did the work because it's a common law.
That's correct. Yes. So essentially, the position here is that there is no authority that a pleading, that a subsequent pleading can supersede a pleading of a completely different type. Here, Massachusetts Rule 7A identifies the types of pleadings allowed, identifies the operative pleadings. It identifies specifically cross-claims, third-party complaints. Rule 13 addresses cross-claims. Rule 14 addresses third-party complaints. So cross-claim is filed pursuant to a separate rule than a third-party complaint. And there's nothing in either of those rules that addresses or that states that a subsequent cross-claim would supersede, supplant, replace a properly filed and answered third-party complaint. So that's the issue. And I believe PCA in their brief cites to a reporter's note to Rule 13, which states under Rule 14, the third-party defendant will not even be potentially liable to the plaintiff unless the plaintiff chooses to specially assert a claim directly against the third-party defendant. That statement does not go on to state that that if the plaintiff specially asserts a claim directly against the third-party defendant, that the underlying third-party complaint is now somehow null and void. There's no indication that the third-party defendant loses its status as a third-party defendant, or that the claims that are asserted in a third-party complaint against them are now somehow null and void.
You don't dispute that there was no incorporation by reference as there was in the national construction case, right? And I'm not sure how that would actually work in taking a third-party complaint to a cross-claim. Well, no, I suppose it could.
Right, that we did not incorporate our third-party complaint into the cross-claim. However, PCA did, with respect to their answer to the cross-claim. They incorporated by reference their answer to the third-party complaint with their affirmative defenses.
You talk a little bit about estoppel, and maybe you could speak to that. I mean, it seems to me that just putting the names on the pleadings doesn't quite get you there. But beyond that, what do you say are the ways in which the parties behaved as if the indemnification and breach of contract were still live causes of action? What are the ways in which that was manifest?
Right. Well, one of the issues is what I just mentioned: the incorporation by reference of the third part of PCA's answer and affirmative defenses to the third-party complaint into their answer to the cross-claim. I mean, if their position at the time was that the third-party complaint was no longer effective, that the claims asserted in there were no longer valid, what are you incorporating? Why are you incorporating? That's a signal that, yeah, we understand that those claims are valid. that they were properly pled, not necessarily that they have merit on the merits, but at least that they were properly pled pursuant to the rules, and discovery can commence on those issues.
And that they still
and can be
exist,
tried.
I suppose.
Right.
That's in PCA's answer to the Second Amendment complaint?
That's in PCA's answer to CEA's cross-claim, that incorporation by reference. So we filed.
Which came first?
Well, we filed the third-party complaint. Plaintiff then moved to amend to file a second amended complaint, which they did.
Right.
We filed an answer with the cross-claim, and then PCA answered both the plaintiff's complaint as well as our cross-claim.
And they answered the cross-claim. In doing so, they actually answered as it related to the indemnification and the breach of contract?
Well, they answered the cross-claim with respect to the way it was pled in our answer to the plaintiff's second amended complaint. Yet they incorporated by reference their affirmative defenses that they assert, specifically that they asserted with respect to the third-party complaint. So incorporating by reference their answer to the second, essentially incorporating by reference their answer to the third-party complaint into their answer to our cross-claim. So essentially
Which would have included affirmative defenses to these two causes of actions, yes or no?
Correct. The indemnification and the breach of contract claims. So essentially, again, signaling that PCA was treating those claims as valid claims at that point.
Did you raise the estoppel claim at the trial court level?
The estoppel argument, well, the procedural history there is a little, it was condensed. Essentially what had occurred, and the answer is, to answer your question straight up, Your Honor, no, we did not. What had happened was that PCA and plaintiffs filed a joint motion for approval of the settlement, as well as entry of judgment in PCA's favor. They raised this argument with respect to waiver basically as a one-line, almost throwaway argument without any support, any case law. They just said, well, it's obvious. It's obvious that a cross-claim supersedes a third-party complaint. It's obvious. Well, it's not. If it was obvious, there'd be some sort of authority on it. We filed our opposition to the motion, to the petition, stating that, no, it's not obvious. There's no authority on this. PCA then responded with a reply brief that they submitted with their Rule 9A package, which cited the two cases, the National Grange as well as the rates case, RAETZ. And that's the first and only time that they asserted any type of authority in support of their position. Again, we believe it's completely inapplicable. And then the court heard oral argument on that essentially 2 days later. And pursuant to Rule 9, we're not permitted to file a cert reply. So the answer is no, we didn't raise it, but the time frame for that was pretty much condensed. So essentially, you know, we have multiple instances of PCA acknowledging the claims, incorporating them into their answer to the cross-claim, which is interesting because it's the cross-claim that they're answering that they're claiming superseded the third-party complaint. So why would you incorporate that? Why would you incorporate your answer to the third-party complaint into the very answer to the very document that you're claiming waived the prior claims? And just to touch on, as I know that PCA did argue as alternative grounds for entry of judgment, that the claims for indemnification and breach of contract fail on their merits. Just wanted to address that very briefly. First of all, the Superior Court did not rule on that argument. It just sidestepped it entirely. And essentially, it was essentially a very untimely motion for summary judgment that was filed basically a year and a half, 2 years after the MSJ deadline expired in 2023. But more importantly, PCA didn't cite any evidence in support of the arguments that they raised with respect to the merits of those two claims. They didn't attach any exhibits. They cite to no documents, no testimony, despite the fact that there is a contract. They didn't attach the contract. We actually did in our response, but for whatever reason, it didn't make it into the Rule 9A package that was filed with the court, so it's not even before this court on appeal. So essentially, there is no appellate record on that issue upon which a decision can be made. So for all of these reasons, and unless there's any further questions, for all these reasons and for those set forth in our briefing, CEA requests that the Superior Court's March 17, 2025 order that entered judgment in PCA's favor pursuant to Rule 54B be reversed.
Thank you.
Thank you, Your Honors.
Mr. Hutchinson.
Good morning, and may it please the court. Warren Hutchison, representing the appellee Prowich Jolimsky Associates, which I will refer to as PCA for simplicity. CEA in this matter is asking this court to undo a settlement and reverse a well-reasoned decision of Judge Gilday of the trial court. And they ask you to do that based on arguments that have no support whatsoever in the law, and most of which have no reference at all in the record, factually or legally.
Could the settlement not survive our reversing, at least on the entry of final
I
judgment?
would suggest, Your Honor, we conditioned the settlement on the dismissal of this case.
Condition, okay.
3 of the 4 arguments raised by CEA were never raised before the trial court. And therefore, Judge Gilday had no opportunity to even address them. And so I suggest that this court should not address them either. Those 3 issues were the application of Rule 41, which we see nowhere in the record other than in the appellate brief. The estoppel argument, although I will say that Judge Gilday did look at that issue in the sense of CEA's conduct, and whether CEA was equitably entitled to assert this third-party claim at this late juncture of the game. But CEA had never advanced the point that somehow PCA had done something to deny it the right to claim that the third-party complaint had been superseded. And then they asked this court to allow them to go back and amend a cross-claim, which again was never presented before Judge Gilday, so he had no opportunity to weigh the issues as to whether there should be an amendment of their cross-claim. He's essentially asking this court to be a trial court and decide whether there should be an amendment to the cross-claim. I suggested because Judge Gilday didn't have an opportunity to adjust those points, it would be unfair for this court to impose on Judge Gilday a reversal of his decision and to suggest that he made a mistake in ruling based on the record he had before him. So with those 3 issues aside, that leaves the one point that CEA did raise. And at the heart of that issue is really whether a party like PCA could simultaneously be a third-party defendant and be a defendant. Because if they can't be both a third-party defendant and a defendant at the same time, there is no third-party claim existing against them. And I suggest that the rules don't recognize that whatsoever. There's no case law to suggest it, and it defies common sense and logic to suggest that an entity that has been sued by the plaintiff and therefore is a party is nevertheless a third party. They're mutually exclusive concepts. You can't be a party and a third party.
So a plaintiff, by amending their complaint, can destroy third-party complaints?
The plaintiff, by amending the complaint, brings what was the third-party defendant into as a defendant, and then the rules say that if there's a claim that a co-defendant has against that defendant, that claim has to be made in a cross-claim. And so it's turning the clock back. It would be the same thing as if the plaintiff sued everyone originally in that regard. The complaint is brand new. We have a brand-new complaint, a brand-new cause of action. The answer then by the defendants become new, and including the CEA defendant, their answer is new. They have to decide at that point, do I want to assert cross-claims against these defendants? And if I do, what are my theories of relief against these co-defendants?
Okay, so just let me walk that back a minute. So you're saying when they file the amended complaint, that essentially, we start everything anew?
Absolutely.
And that's, okay. Why then did you incorporate answers to the amended complaint that appear at least to respond to the claims of indemnification and breach of contract?
That's a common, I suggest, device that you use. It's just like incorporating by reference prior allegations. If we weren't incorporating our admission that there was a claim out there. We were simply incorporating defenses, which included defenses to the contribution claim. So we were simply saying that to the extent these defenses would apply to this claim, we're incorporating them by reference. And maybe they wouldn't, and maybe they would then move to strike some of the defenses because they wouldn't apply. But no way does the incorporation by reference of defenses in another document somehow create a new claim in the document you're responding to.
But that other document wouldn't exist, though, right?
I'm sorry?
The other document doesn't exist anymore because it started all over again
Exactly,
with the second
because
part of the complaint.
it's been.
So you incorporated by reference and that didn't exist?
Well, again, you can incorporate by reference. It would be like, amending your answers to interrogatories and incorporating by reference prior. I mean, it's still a document that's out there, but the document doesn't define anything other than, if you want to go back and look at it to see how it applies to your answer to the cross-claim, not the third-party complaint, if you want to see how it applies to the answer to the cross-claim, if you've incorporated a defense that would apply, then the defense exists.
So on your theory, and perhaps it's obvious, if they did not cross-claim on contribution, that's gone too.
That's right. That's right.
Because once the amended complaint is filed, then the third-party complaint becomes a nullity. That's what you said.
Exactly, Your Honor.
And there are no cases that say that. You agree with that?
I would suggest that a close call is the Bank of America case.
That's what a 128 used to be. What was
right?
It's
Right.
no case.
But it's the only. That's all we have, right?
Right.
And in that case, the defendant didn't reassert the counterclaim, right? And if the law was that another pleading that defined a claim that wasn't necessarily affected by the amended complaint still survived, that case would have gone in another direction, because this court would have then said, well, you didn't have to amend your cross-claim, you didn't have to amend your answer because we already had you already had your cross-claim, I'm sorry, your counterclaim out there. But the court said, no, no, no. When there was a new complaint that basically started the clock again, you had to file an answer, and with the answer, you had to file a new counterclaim if you intended to assert a counterclaim. So I suggest that the Bank of America case, again, it's not perfect, but it certainly can inform this court that that it was incumbent on CEA in this situation, if it intended to assert a claim against what were then defendants, not third-party defendants, but were then defendants, it has a requirement under the rules to assert those claims in a cross-claim.
Is this an unusual occurrence in your experience? It just strikes me that there's nothing since 1980, at least in the appellate world on this in this state. And
I think it's just
unusual for amended complaints and cross-claims and third-party complaints and.
Right. Well, I think in most situations it's just assumed that, again, once there's an amendment, again, unless there's an incorporation by reference, that amendment is the new document, the new controlling document, and it supersedes what's come before it. I've been practicing law for more than 40 years. I've never seen a situation before this one where a party suggested that even though there was a new pleading filed, that somehow they could go back in time to a prior pleading and suggest that what they were alleging in that prior pleading that didn't exist in their new pleading somehow had effect. I just don't think it happens. That's why we haven't seen any cases on it.
So is your take on CEA's answer to the Second Amendment complaint that they intentionally abandoned the indemnification and contract claims against what are now the co-defendants, or it was just a mistake?
Well, I can't get into their minds, but I suggested from PCA's perspective, it was intentional, and it was what PCA relied upon, because as Judge Gilday, and I will just address it, the estoppel point again, not raised in connection with PCA being estopped, but Judge Gilday did address that in his decision in terms of whether CEA should be estopped, in arguing at this point now that somehow it still had these claims alive. And he pointed to the fact that nowhere in any pleading that was brought to his attention, and I submit that we've looked through the pleadings as well, and there aren't any, did CEA reaffirm in any way, shape, or form that it was continuing on with a claim for indemnity or breach of contract against PCA. And the final trial, pre-trial memo just reinforces that. Judge Gilday did have that, and he went through that.
So can you explain that? Because I looked hard, I thought, it seemed to me that would be a good place to look, so I did. And I read it a couple times, and it may be just me, but I couldn't get a feel for whether it informed that issue one way or the other. Tell me why it informs that question in your favor.
Well, because in the statement to be read to the jury, there's no reference whatsoever to a claim against PCA for breach of contract or common law indemnity. If you look at the...
Is there one on contribution?
No, it's contribution, but I submit that
Right.
contribution is typically not submitted to the jury.
Fair enough. No, fair
Because the judge would basically decide that if there's common liability asserted. So that type of claim wouldn't even be presented to the jury in terms of a jury verdict form, because it's automatic by law. If it's joint liability and tort, then there's liability. But the other claims did require findings by the jury. And there was nothing referenced in the pretrial memo that said that we were going to raise before this jury issues of breach of contract or common law indemnity. And the only estoppel that they claim that we did wrong was we allowed some sloppy drafting, and I admit it was sloppy in terms of they pick out 5 pleadings where old captions were inserted. And all but I think one of those, there was nothing in the body of the document that said anything about PCA being a third-party defendant. Some of those captions you'll see don't even identify PCA or Callahan as defendants, that they went back to pre-amendment pleadings. But I suggest to you, Your Honors, that perhaps the most telling document, and it's in the record, 207, is CEA's opposition to our motion to have this petition for approval of the settlement allowed by the judge. And in their pleading, they identify PCA and Callahan only as defendants. They do not even, as they raise before the judge that we still have these third-party claims out there, they do not put before the court a caption that identifies PCA as a third-party defendant.
How is that any more telling than the captions that you folks used?
Well, because, again, there were, I would submit, they identify 5 of them, Your Honor. We did a quick survey. There are over 100, our count was 102, pleadings on the docket that did not have PCA as a third-party defendant. And they found 4 or 5.
Okay.
So I submit that 4 or 5 represents a just sloppy draftsmanship, cutting and pasting from other documents. But CEA did not before the judge and hasn't before this court identified anything that they relied upon to suggest that they were then pursuing that those third-party claims for indemnification and for breach of contract based upon sloppy captions. Because, again, what you want to look at is what's in the documents. What is CEA claiming the case is about? What are they going to prove at court? What are they going to prove at trial? So I submit, Your Honors, that there's no factual record on which this court can claim that PCA is stopped from anything other than believing, as Judge Gilday found in his decision, that they should, that the contribution claim was the only claim that CEA intended to pursue, that...
Can I ask you one more question? Your time is short. If we were to reverse the dismissal of their third-party claims, what would be the effect on the grant? I mean, the question is, how are you prejudiced? But what would happen? Your settlement would be gone.
Settlement argument would be
gone. There was a trial that ended in a mistrial
the trial's been rescheduled for February 26th, I believe, so next month.
So, and that is that, and who are the parties in that?
The parties right now are only CEA and the plaintiffs.
Callahan?
Callahan's out.
Callahan is out?
I said Callahan settled, and Callahan similarly got a ruling of dismissal, but the judge did not give him a 54B order.
Okay.
Oof. All right. Okay. Thank you. Thank you both.
Okay. Thank you.
Our last case is 24P 1412 Tucker versus Harris. Ms. Pinheiro. Did I say that one correctly?
Yes.
On a roll.
Good morning, Your Honor. If it please the court. This is a case where during trial the exclusion of probative and relevant text messages, which clearly fell within the well-established hearsay exceptions, left the jury unable to appreciate and consider significant information about the facts of this case.
So the defendants make a good point about your lack of adherence to Rule 16A9. Are you familiar with 16A9?
Not off the top of my head, Your Honor.
You have to support your arguments with citation to the record. You don't identify the emails or messages on 23 to 24, again on 28, and then again on 34 of your brief. You don't identify which messages or what the content is of those messages. So the purpose of a brief is to help the court find in your favor, not an invitation to a judicial treasure hunt. Are we supposed to guess which emails in the record you're talking about?
They were included in the record appendix, and there were references.
And I understand that, but it's not our job to comb through the record appendix and guess on which emails you're talking about. Rule 16A9 requires you to cite to the record. So we know what you're talking about in the appendix.
Your Honor, this is the second time I have actually been in the appeals court, and my apologies for not having complete, full understanding of the rules as I should have.
That's not an excuse, and we don't have to pass on questions that violate 16A9.
I would ask the court that the particular emails are just a few pages, which, if I understood you correctly, you knew which ones that I was talking about. And if you can see from the exhibits that are referenced in the records appendix do actually say, I mean, you can see that the vast majority of them are blocked out, along with reference to or incorporation of the...
Go ahead with your argument. We'll see what we can identify based on your vague references.
Thank you, Your Honor.
Can I ask you,
I'm sorry. No,
You just said email, but it seems to me that the one thing that I could generally figure out is that you were talking about texts.
Yes, so the electronic communications consisted of text messages, emails, and a transcript which is only of 2 lines, of a paging system. Those were the 3 that were representative. The issue that I'm representing.
What issue do they pertain? That was the question I was going to
Pertain
ask.
to are the text messages.
No, to what issue do those messages, electronic, in whatever form, pertain? To what issue in the case?
They pertain to the violations of the standard of care and causation, foreseeability.
Okay, so tell me, you're trying to, in terms of like the text from is it Dr. Hayne, H-E-Y-N-E?
Yes.
That's the main thing you're trying to get in, right?
Those.
What is the main, what is the most egregious thing that you really wish you could get in? Where is it? Tell us what it is.
It is the text messages between Dr. Hine, who was a doctor caring for Maria Tucker, and Dr.
Well, he was
McNeil,
home, right?
who is a defendant.
Okay, but Hine was home at the time of these texts,
Yes,
right?
he had cared for her all during the day, and he was returning the
So
following
what
day
in there
to
does
care
he
for her.
say that you really want in? And why is it admissible?
Dr. Hine's text messages show what I would consider an excited.
A particular
You want me to
thing-
read them? Is that what you're asking?
Yeah.
Okay. I'm sorry, I misunderstood you.
A page reference, too. Thank you. I think it's Record Appendix, we're looking at, the best ones are Record Appendix 1, start around page 170.
172, I believe, 170 to 174.
So which one there's like, what's your best one?
I'm sorry.
What's the best one for you? What's the one that you really, really want?
That Maria Tucker's mortality was very high.
Her mortality is super high.
Yes.
And that shows what?
Foreseeability. This was a young woman who was admitted to the intensive care unit
No,
after an
I
infective
understand the
event.
facts.
And Dr. Hine is actually providing warning to his younger resident that he is partially training. He was there during the day.
So why is it, he is saying, it's an out-of-court statement, her mortality is super high.
Right.
He's not a defendant, right?
That is correct.
So what is that? Yeah, you want to prove that her mortality, you want to get it in for the truth of the matter asserted.
Well, I want to show, I'm not offering it for the fact that her mortality was super high. I'm offering to show that he gave warning to Dr. McNeil, who's a defendant. He gave warning about the patient's condition and the risk of harm to to her.
That sounds like the truth to me.
And that in turn then shows she had knowledge, Dr. McNeil had knowledge of the harm that could occur, and in this case, death of her patient.
But that's only true if, in fact, the statement in the warning is true, right?
Well, it's showing that he's giving her warning about a patient.
Okay. And so are you talking about the receiving party's state of mind? Are you talking?
And yes, I would get to that. Yes, and as we look through these text messages.
It's the only conceivable admissible exception to, or admissible purpose as an exception to the hearsay rule. But I don't know that it's even there.
Dr. Hine, his response would fall under an excited utterance. He's seems surprised by the language he uses.
Did you make an offer of proof along that line?
There was a motion in limine to admit it, and that was included. That was the
argument.
That was the argument. It was an excited utterance, and that he further goes on to say, "I've never seen them do that before," meaning that this is a rarity, which goes to a violation of the standard of care. The experts have testified that this is an unusual time to suddenly change a plan of care at 11 o'clock on a Sunday night, and that was expert testimony. However, what supports that is that Dr. Hine's text messages say, "I've never seen them do that before," which shows that this is a rare event.
So, but you want that for the truth of them. You want it for the truth of the matter that this is a rare event.
No, I just want to show that he's surprised by this, and this is rare.
Okay.
Okay. Do you want to talk about causation? You said the judge limited the experts from testifying on causation.
Yes.
But
So-
let me ask you this. Once the jury's determined there hasn't been a breach of the standard of care, you can't make your case, so why does causation matter?
That's just one aspect of it. The other aspect, not causation alone, I mean, that came up, and that's not the primary focus, because
That's the focus of my question, though.
the focus of your question with regards, you're absolutely right, Your Honor. If you don't get by negligence, you're not going to get to causation.
And that's what occurred here.
In part, that's what occurred here.
Did you establish a breach of the standard of care?
The jury did not find that for negligence.
So it seems any issue related to causation goes away.
Understand that that's true, that it would go away. It's a hand-in-hand argument of the failure to bring in these relevant and probative electronic communications prevented negligence, and thus, of course, the expert was not allowed at all to testify to causation.
Relative to the motion to preclude the reptile tactics, you argue on appeal that this is a prior restraint and a violation of the First Amendment and the Declaration of Rights, correct?
Correct.
Did you make that claim below?
Yes.
Where?
In plaintiff's opposition to defendant's motions in limine.
I read the opposition, and correct me if I'm wrong, but it was only a couple pages, and it made no reference to prior restraint.
I believe it was.
Or the First Amendment.
I think it was close to the end of the opposition where statements were made in the record of how trial strategy and is when a court precludes, and I am paraphrasing the strategy in a case that it constitutes prior restraint.
Well,
So we'd find this up-
let's assume it's preserved. Why a prior restraint is a restraint on free speech? What leads you to believe you have a right to free speech in a trial?
I don't believe that a lawyer leaves their First Amendment rights at the courtroom door when we walk in.
Well, let me suggest that I don't agree with that, because we have rules of evidence, we have rules of procedure, we have the judge's discretion. He or she is running the court, and they get to decide what is said and not said. It's not if you want to complain about safety standards of a hospital, you can go to the public square and get on a soapbox and do that, but that doesn't mean you can do it at a trial. And the only authority you cite is an unpublished decision from the Western District of Washington, which I'll go as far as to say I don't find persuasive, because it was a one-sentence throwaway in his order on a motion in limine. And he didn't cite any authority for it either. I think it's a he.
I would.
So help me out. What's your authority for your right to free speech and prior restraints in the midst of a trial?
I would say, Your Honor, that patient safety is addressed not only in the healthcare arena everywhere, but also the Massachusetts.
Judge Wilson spent a lot of time with you on the record about this, and that you are not to bring up safety issues or standards of cares or CMRs, right? And that you nonetheless mentioned them several times in your opening statement.
In my opening statement, I did mention patient safety. Judge Wilson, what he said is, I cannot say the word safety rules, and I actually clarified it with him and very specifically asked him, and it's referenced right in the brief, that I can't say safety rules, and he said, yes, don't say safety rules. He never, ever indicated prior to the start of the opening statement that I couldn't say safety. And in fact,
let me ask you this then.
The Mass Guide to Evidence.
Let me ask you this. In the disclosure of any of your experts, did they explain that the standard of care was deviated based on violation of safety rules?
They did mention safety rules. They did mention, they did
which
obviously
expert-
opine.
which expert
I
was that?
believe it was Dr. Early, and I believe it was Dr. Gluck.
Gluck was never asked anything more than the standard of care. He didn't get into causation, right?
I believe he did when he said that they violated the standard of care and the cause of death
You didn't
leading
ask him
to her
about
death.
you didn't ask about causation.
I did ask about causation, and
Where's
I
that?
believe...
Where's that in the record? You can send us a Rule 22 letter explaining where that is in the record. So can I ask you, too, about the judge's refusal to instruct on conscience of guilt? Guilt doesn't seem to be an issue in a civil case or a malpractice case.
I believe it's referred more to consciousness of liability when we're dealing with civil cases. I know in the guides to evidence it references it both ways.
Did you lay a foundation for consciousness of liability?
Yes, had the text messages come in and
This turns on the text message.
allowed to, and I was allowed to ask the defendants during cross-examination about whether they believed that this was unsafe to discharge Maria Tucker. Consciousness of liability would have come in. And we had emails showing that the conduct following Maria Tucker's death was such, there was a flurry of emails, there was a flurry of communications that indicated that this was a pretty big event, that a young 26-year-old died within 20 minutes after leaving their care. And that activity, in my estimation, was evidence of consciousness of guilt.
Okay, thank you. We'll take it. Thank you for your argument.
Thank you for your patience, Your Honors.
Ms. Corcoran's going first.
Good morning. May it please the court. My name is Molly Corcoran, and I represent the defendant, Dr. Jenna McNeil, in this case. I'm going to be addressing plaintiff appellant's contentions that she was unfairly deprived of showing the jury certain electronic communications during the course of the trial. And first, I want to emphasize for the court that the standard of review here is abuse of discretion. A judge's discretionary decision constitutes an abuse of discretion where we conclude the judge made a clear error of judgment in weighing the factors relevant to the decision, such that the decision falls outside of the range of reasonable alternatives. The Supreme Judicial Court has articulated descriptions of such decisions as decisions based on whimsy.
I'm sorry, you only have a few minutes. We understand abuse of discretion.
Can I ask you this one? What is the basis for keeping out your client's statement, nurses making me discharge peeps without safe dispo plans?
So the court considered the arguments put forth by plaintiff appellant for keeping the statement in and reasoned that that particular text message should be excluded on the basis that any probative value of which it was questionable was substantially outweighed by the potential for the prejudice as to the nurse defendants, and also considered the fact that in this case, the statement about the nurses making me discharge peeps without safe dispo plans had no support with the expert testimony that had been presented at that time by plaintiff appellant. The judge had already ruled...
The concern was that the jury would take from that in fact they were unsafe discharge plans.
Yes, there were a number of concerns articulated. Number one was that the jury would take away that this was a statement as to the standard of care. And in a medical malpractice case, the standard of care is not safety or what is safe. And what was being articulated by Dr. McNeil in this text message was actually a concern about the decedent's potential to use heroin again, and that concern of safety. And so there was a substantial risk of prejudice that the jury would hear that text messages and conflate it with a statement about a deviation from the standard of care, and conflate it with the plaintiff's theory of the case, which was that the patient was actually at risk for another asthma exacerbation, which was her theory of the case from day one of this litigation up until the conclusion of the trial. And that's an important distinction to make here, where she tries to offer these text messages as highly probative evidence as to the standard of care and as to her theory of causation on this case, which had nothing to do with heroin use. These text messages have everything to do with Dr. McNeil's concern about the patient's use of heroin in the future. And so the judge, in his discretion...
I'm sorry, her safety planning theory at trial didn't have to do with drug use. It had to do just with ventilator and stuff like that. Is that?
So yes, the plaintiff's theory of the case was that the decedent ultimately, unfortunately, died due to an asthma exacerbation, and that was because she was improperly discharged too early before her lungs had the ability to recover, and that from a respiratory standpoint, she was unstable. These text messages and throughout trial, Dr. McNeil did testify to the jury over and over again. She admitted that she had inner turmoil about the discharge, about the circumstances of the discharge, not because of any concern for respiratory stability, but because she was concerned about the decedent's potential to use heroin. And so because of the limited probative value associated with the statement from Dr. McNeil saying unsafe dispo plans, given the attempt for plaintiff to use that as to her theory of the case versus what she was actually saying, the judge duly excluded that message, also considering the fact that the statement says, "Nurses making me discharge peeps." The plaintiff's experts had no time ever articulated an expert opinion that there was any ability or authority for either the nurse defendants or Dr. McNeil as a second-year resident to discharge patients. And where this statement would potentially prejudice the jurors into believing that they had that authority, where there was no expert testimony to that effect, the judge again considered the potential for the prejudicial effect. Thirdly, the judge also considered the potential for prejudice to the nurse defendants for this statement, which he had deemed to be hearsay as to the nurses.
We're gonna hold you there.
Okay.
This is a clumsy way to do this, but next.
Okay.
Ms. Moeller, for me, it's clumsy. I have questions, and I don't know which one of you to ask, so I hope you all can answer all questions.
Good morning, Your Honors. May it please the Court, Emily Moeller, I represent Dr. Harris. I'll be addressing the alleged violations of the First Amendment, the prior restraint issue, as well as the impartiality of the trial.
Can I ask you anything about causation?
You may ask, but Attorney Ferris is also
All right, then I'll leave it for her. Thank you.
In this instance, the verdict should be affirmed because the plaintiff was afforded a fair and impartial trial. There were no violations of the First Amendment. For example, as Your Honor asked, whether evidentiary ruling with respect to what can be admitted at trial or discussed at trial can constitute a prior restraint on the First Amendment of speech, I would submit that the answer in this instance is certainly not. The plaintiff
It would make appeals far more difficult.
Excuse me?
It would make appeals far more difficult if it was protected.
Certainly, Your Honor. In addition, it's an attempt by the plaintiff to salvage this case when, in reality, the trial judge very meticulously throughout 16 trial days, 3 of which included impanelment as well as a full-day final trial conference, regularly addressed and heard arguments from both sides about what could and could not be admitted at trial and explained the reasoning for his decisions.
Can I ask you, if we reject your argument and we accept that there were some First Amendment violations here, do you think that would apply to us too? Like, can we not ask you questions or tell you what you can argue and not argue? With that logic, I'm trying to think that through. Or if we say, for example, in the last, if you were watching before, don't use a child's name, we restricting, is that a First Amendment violation?
The First Amendment is a quite unique area of law. In this instance, that it goes to show why there are no cases on point that can be cited, because it does not rise to the level of a First Amendment violation imposed by the court.
Not exactly the Pentagon Papers.
It's quite
That's a prior
different
restraint
scenario
case.
that we're dealing with on this appeal.
It's a famous prior restraint case by the Supreme Court. Might be the prior restraint case, but fair enough.
In this instance, the allegation of prior restraint is actually evidentiary rulings for which there are numerous grounds, as Your Honor mentioned before, the rules of evidence, whether something is more prejudicial versus probative, whether it can be excluded based on hearsay. And in this instance, it was a combination of all of those things. At heart was the attempts by plaintiff's counsel at trial to use the term safety rules as sort of an overarching supplementation or supplantation, of the standard of care. There were also vague references to policies. Now, policies were not admitted at the trial. In the pretrial conference, the court made the decision that they were inadmissible hearsay under the Broussard cases, as well as there was the potential for confusion for the conflation with the question at issue here, which was whether the individual defendants complied with the applicable standard of care, not whether they complied with policies. The decisions to preclude the use of the term safety rules was appropriate and an appropriate exercise of the court's discretion in that regard.
So I just don't remember the record, but was there a lot of conversation about the First Amendment at trial?
No.
Okay, that's why it wasn't something large that I just blew through, skimmed over.
Is it in the plaintiff's opposition in the motion in limine?
I do not know whether it was in the opposition to the motion in limine. I do know that bias of the trial judge did come up in the mistrial, in the mid-trial motion. It may be mentioned in there. I'm not certain. But it was not mentioned in.
Those are good things to know when you come here, because if it wasn't raised below, it's waived.
Yes, as we have addressed that things were not properly preserved or cited in our brief. In addition, the impartiality of the trial judge was very clear. He, throughout the course of the trial, and looking at the record as a whole, as I mentioned, 16 days of trial, as well as a full trial conference, is replete with examples of listening to both sides, thorough reasoning. It was all based in the law, not on extrajudicial sources, and therefore there are no grounds for a new trial based on the conduct of the trial judge. With that, unless there are further questions on these issues, we'll rest on our briefs.
Thank you. Ms. Ferris.
Your Honors, Teresa Ferris. I represent the two nurses here, Megan Devlin and Christine McCarthy. I'm going to talk to you about causation, the fact that there was a finding of no negligence, and that the evidence of stigma within the medical community was properly excluded.
Can I ask you?
Judge Meade, you have questions on causation?
I do, and they're short.
And I should tell you, I'm quite hard of hearing.
Okay, I'll turn up the volume. You write in your brief that the plaintiff disclosed Nurse Smith and Dr. Gluck would testify to causation, but they also mention a Dr. Paul Early who was going to talk about substance abuse disorder. You don't reference.
He did testify about standard of care regarding substance abuse disorder. We moved to preclude him as an expert because his testimony was not tied to any causation issue. It was simply on a breach of the standard of care, so it was a 1 peg out of 3. but he was allowed to
But
testify.
he testified anyway. Okay, I see.
He did not testify on causation.
And Dr., do we say it's Hain or Haney?
Dr. Hines.
Hein, excuse me. He was not disclosed as an expert in this
No.
case.
No, simply a
So-
fact
so would
witness.
he-
And it's not even clear that Dr. Hines, there were 2 teams in the ICU. It's not even clear that Dr. Hines ever treated Maria Tucker. That was never established.
So he wouldn't be able to give an expert opinion contained in a text message, even if it was admissible?
No,
Thank you.
there was no disclosure in that regard.
Well, why did he say that, you know, she's a, what is it, like she's a high-risk patient or something, if he didn't have anything?
sorry,
wrong?
Justin.
I'm sorry. That text that's kept out, he says she's a high-risk patient or something, right? I mean, so how does he know that?
How does who know what?
How does Dr. Hein know that?
Yeah, I'm not sure. Perhaps just from the hearsay provided to him by Dr. McNeil.
He
It's
wasn't
it's
treating
all
her.
hearsay as to the nurses in particular.
Hein didn't treat her earlier in the day?
It's not been established. There are 2 teams in the ICU team, a blue team and a red team, and he was on one of them. I don't think he ever testified that he treated her. I think he testified years later that he was in the ICU that day, but not that he was not on duty then. He was not supervising
That was my
Dr.
question.
McNeil at the time. He made that
Is
very
there any,
clear at
is there any,
trial.
is there any evidence that he's her supervisor in any circumstances?
I suppose if he had been on the floor, he's a more senior resident, but that doesn't mean a supervisor. He's not an attending physician, if you will. But at the time and at trial, Dr. Hines was very, very clear. He was not operating in a supervisory capacity over Dr. McNeil. He was simply, as he described it, a shoulder to cry on. At trial, plaintiffs sought to introduce evidence of the stigma within the medical community against those with substance abuse disorder. We moved to preclude it. The judge said it could come in if plaintiff laid a foundation. She did not. She identified Dr. Early and Dr. Smith, Nurse Smith, to testify on these 2 issues. When she did not seek to bring it in with Dr. Early, who was the very first witness in the case. On day 8, I believe, Nurse Smith testified, and plaintiff sought to introduce evidence of stigma at that time. When it became clear that that was the direction that the questioning was going in, objection was made by trial counsel. And at sidebar, the judge told her, you haven't laid the foundation that I said you must in order to admit this evidence. The offer of proof that was made at that time was that this nurse has education, training, and experience. The judge made it palpably clear that what he was talking about was foundational evidence as to these defendants, not generally. We do not try defendants in medical malpractice cases based on innuendo or the suggestion that they're biased without actual firm footing that they hold such bias or prejudices. The other issue I was going to speak to today was causation. I won't belabor the point too long, but there was a finding of no negligence. Jury went out at 1 o'clock, came back at 3:20 with lunch. No negligence across the board. Even if this
is a special verdict slip?
Yes, and it's in the record. Even if this court were for some unforeseen reason to overturn the finding of the jury and the verdict, and on the issue of negligence, there was no evidence of causation. Before trial, we moved to exclude the testimony of Nurse Smith on the grounds that she herself testified she's not
wasn't qualified, right. We're going to have to leave it,
And Dr.
we're going to leave it
Gluck,
there.
as you see in the record and in our brief,
Okay.
did not
We're
testify.
going to leave it there. Your time is up.
Oh, thank you, Your Honor.
Thank you. Thank you all. We'll take this under advisement. With that, our session will come to a close. I'd like to thank our court staff, our court officers, our clerk's office, my panel, our law clerks, and the excellent timekeeper. With that, we'll stand in recess.